The H1B guy here, and today I'm going to discuss HR865, American Jobs First Act of 2021, H1B visa reform introduced by Representative Brooks. Today I'm going to cover new H1B wage minimum, protection against American worker displacement, LCA posting requirements, abuse investigations, and eliminating the diversity visa lottery. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention the H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues and the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. Today's post is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. HR 865, American Jobs First Act of 2021, was introduced by Mr. Brooks of Alabama, Mr. Gates of Florida, and Mr. Gooden of Texas on February 5th, 2021. This piece of legislation seeks to amend the Immigration and Nationality Act to improve the H-1B visa program, to repeal the diversity visa lottery program, and for other purposes. Back on October 1st, 2020, in a news release from Representative Brooks' website titled, "Congressman Mo Brooks introduces the American Jobs First Act to stop American worker replacement by cheap foreign labor." Quote, "The American Jobs First Act stops employers from hiring H-1B workers if they have recently or plan to furlough U.S. workers, requires employers to pay their H-1B workers more than their American workers to ensure foreign labor is only used when absolutely necessary, suspends the F-1 OPT program, which grants all foreign students extendable work permits and exacerbates job market competition among American graduates, ends the unfair diversity visa lottery program, which fails to serve U.S. interests by issuing 50,000 green cards to foreigners from around the world regardless of their qualifications." Congressman Brooks said the H-1B visa program is supposed to give employers a route to recruit the high-skilled talent they need, and only if they cannot find a qualified American worker. Due to abuses, the H-1B visa program has become a cheap foreign labor pipeline that major companies abuse to increase profits at American workers' expense. My American Jobs First Act will bring much-needed reform and oversight to the H-1B visa program to ensure that U.S. workers are no longer disadvantaged in their own country. To end the allure of cheap foreign labor, the bill will require employers to pay any H-1B workers a minimum amount of $110,000, and to stop American worker replacement, my bill will require companies seeking H-1B labor to not have fired any American workers for at least 2 years without just cause, and commit to not firing any workers without just cause for 2 years after. Common sense H-1B reform measures like these, alongside ending the unfair optional practical training program, OPT, and diversity lottery programs, all serve to promote American interests when it comes to immigration. So let's take a look at the new modified text, which does eliminating the OPT, to see how Representative Brooks plans to do so in 2021. So number one, in general, an alien may not be admitted or provided status as an H-1B non-immigrant in occupational classifications unless the petitioner employer has filed with the Secretary of Labor an application stating the following. Roman numeral 2, $110,000 if offered not later than 1 year after the date of the enactment of the American Jobs First Act of 2021, which amount shall be annually adjusted for inflation by July 1st of each year. Roman numeral 3, after the employer has filed an application under this subsection, offer to an H-1B non-immigrant during the non-immigrant's period of authorized employment, on the same basis and accordance with the same criteria as the employer offers to United States citizens or lawful permanent residents benefits and eligibility for benefits, including AA, the opportunity to participate in health, life, disability, and other insurance plans. B, the opportunity to participate in retirement and savings plans. And C, cash bonuses and non-cash compensations such as stock options, whether or not compensation is based on performance. So if HR 865, American Jobs First Act of 2021, were to become law, then the minimum salary required for H-1B visa employees would be $110,000 annual from 1 year of the enactment. This point cannot be missed. Gone would be wage levels 1 and 2, and even possibly 3. And this number would be eligible to be increased based on inflation annually each July 1st. One thing I do find interesting about Section 3 CCC is its reference to cash bonuses and non-cash compensation. One of the most popular questions I get asked frequently is if cash bonuses and stock options count towards the overall annual compensation of an H-1B employee. That answer has always been no. And even with this new text here in this bill proposing HR 865, it still doesn't appear to be any different, meaning that cash bonuses and stock options would not be included in the overall compensation. Moving back to the text of the bill, Section E, lowercase I, the petitioner employer will not replace a United States citizen or lawful permanent resident with one or more immigrants. Roman numeral 2 will not contract any third party to provide a non-immigrant to replace any United States citizens or lawful permanent resident. And Roman numeral 3 has not displaced, furloughed, terminated without cause, or otherwise involuntary separated, and will not displace, furlough, terminate without cause, or otherwise involuntary separate a United States citizen or lawful permanent resident employed by the petitioner employer during the 4-year period beginning on the date that is 2 years before the date on which the petitioner employer filed any visa petition supported by the application. And then F, the petitioner employer will not place an H-1B non-immigrant employee with another employer unless the petitioner employer, after diligent inquiry of the other employer, has no knowledge that during the 4-year period beginning 2 years before the date on which the employee was placed with the other employer has displaced or intends to displace a United States citizen or lawful permanent resident employed by the other employer. So a lot of displacement conversation here in this language. Really the displacement of U.S. workers has historically been one of the biggest arguments against H-1B visa reform going back to the early 2000s. Section F is really specific in that it is targeting third-party in-client worksite placements. It puts a 4-year window around when an H-1B employee can be placed at a third-party worksite, dependent upon removing, terminating, furloughing a U.S. employee. So very interesting language here. And I'd say this is definitely a carryover from President Trump era that intends to reduce the number of placements at third-party in-client worksites from H-1B employees. Moving back to the bill text in Section 2, notification and transparency requirements. Lowercase I, electronic publication. Not later than 1 business day after the date on which an application is filed in accordance with paragraph 1, the petitioner employer shall, Roman numeral 1, electronically mail a copy of such application and necessary accompanying documents to all employees at all business locations and work sites to ensure employer-wide employee awareness of the application. And 2, post an electronic copy of the application and such accompanying documentation as are necessary on a publicly accessible website to ensure public awareness of the application. And lowercase I, physical posting. not later than 5 business days after the date on which an application is filed in accordance with paragraph 1. The petitioner employer shall post copies of such application and necessary accompanying documentation in prominent places at all businesses, locations, and work sites to ensure that all of its employees are aware of the application. Electronic LCAs and automation around LCA filings and storing them has really increased significantly in the last 2 to 3 years as electronic storage for public access files, PAF, has become the norm. The physical posting requirements are a bit puzzling as the text would require notifications to be published at all business locations and work sites to ensure that all employees are aware of the application. Physical LCA postings are the biggest waste of time and paper. I will say that generally they are posted in a break room or HR or manager office, and that these notices are very rarely ever read by anyone. In fact, in all my years of posting physical notices, I've never received one question about any of the notices we've posted. Going back to the bill text, Section 3, H1B application investigations. Roman numeral 3, any foreign national hired for work in the United States pursuant to a non-immigrant visa who believes he or she is subject to potentially unlawful workplace conditions or requirements. Lowercase 3i's process for which national complainants, the Secretary of Labor and the Secretary of Homeland Security shall devise a process under which an H-1B non-immigrant who files a complaint regarding a violation under this subsection is otherwise eligible to remain and work in the United States may be allowed to seek other appropriate employment in the United States for a period not to exceed the maximum period of stay authorized for such non-immigrant classifications. This text feels like they were trying to include the whistleblower rule without calling it that. Regardless, there needs to be protections for H-1B employees. The section on H-1B application investigations has a lot of text in it. But the big takeaway here for you is that these protections for H-1B employees and harsher penalties for employers who are abusing H-1B visas are on the horizon, as this reform is something that continues to be introduced. And wrapping up down at the bottom of the text of the bill, Section 301, repeal the diversity visa lottery. And just like that, the diversity visa lottery would be eliminated. The irony is that the U.S. Citizenship Act of 2021 text includes increasing diversity visa lottery to 80,000. I honestly doubt the elimination of DV will ever happen, but not surprising to see this language introduced by the America First faction. HR865 is going to be very interesting to watch. If this bill gains traction in the House where there is a strong Democratic majority, it will be very telling about if we'll see stricter requirements surrounding H-1B reform going forward. The 50-50 rule and the whistleblower rule were two very big amendments added to S-386 as part of the unanimous consent negotiations last year in the Senate that later died in the House. With that being said, I want to give Representative Brooks some credit here. This text has a significant bias towards protecting American workers from H-1B visa displacement and helps give abuse protections to H-1B employees. These are two things that I'm very much a proponent of. However, it misses the mark. First of all, a $110,000 minimum salary will never see the light of day. Second, it doesn't account for bonuses and stock options as part of the overall compensation package. Third, regulating a 4-year window for third-party in-client worksite placements will be impossible, specifically when referring to terminations and furloughs of U.S.-based employees. Fourth, a physical posting for LCAs at every location of the business will never happen. Fifth, H1B employees need protections for reporting abuse, and eventually, I believe we will see them become law. And sixth, I find it hard to believe that Congress is ever going to remove the diversity visa lottery. I'll continue to monitor the progress of HR 865 as it moves through the House of Representatives. To read the full post on HR 865, American Jobs First Act of 2021, H1B visa reform introduced by Representative Brooks, please check out the H1BGuy.com. And a reminder that today's post was brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. This national job board network provides recruitment websites in 1,024 major U.S. metro areas. Each local job board is its own portal and is a low-cost resource for immigration recruitment ads for all industries and professions with a flat price of $225 per ad, regardless of which city you choose. RecruiterNetworks.com has been the #1 place for immigration attorneys, immigration ad agencies, and employers to meet the DOL requirements for the digital portion of the perm advertisement rules. RecruiterNetworks.com. Tell them the H1B guy sent you. If you've made it this far, I just want to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we post new content here to this channel. I just want to say thank you for taking the time to watch this video. I really appreciate your support. The H1B Guy, your global source for all things H1B.